Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, had to take a few days off, run down to Houston for some business. That was an eventful trip, to say the least. But now that I'm back, we need to start talking again about the pistol brace rule. Now, frequently when I'm talking about the pistol brace rule is either what the hell does this all mean, or here's more bad news on top of more bad news. Many of you have been wondering, hey, when is somebody going to do something to stop all of this? Well, I think we might finally have an answer, and I kind of want to start getting you guys up to speed on it so you can start tracking it yourself. So today, let's spend a couple very important minutes and talk about, here comes the first lawsuit to stop ATF's pistol brace rule. Okay, so the issue we're talking about yet again today is the pistol brace rule, but more importantly, we finally have the first lawsuit brought in this matter. The suit is called Mock v. Garland. It is filed in the Northern District of Texas. Always a good venue to do this. And it is brought to you by our good friends at the Firearms Policy Coalition. Now, before we get too far in this lawsuit, a lot of you have been asking, between the pistol brace rule and some of the things that are going on in some of the states and all the crazy gun grabbing measures, who can I donate to? Who really is actually fighting for my rights? And as I'm talking about this, I'm going to show you four logos of organizations that I really strongly believe in, I think very highly of. And if you go back, and I'm not, I try to do everything here based upon objective evidence at Washington Gun Law. We don't really want to tell you guys how to think. We just want to give you the stuff to think about. And what I base this on is if you go around the country and you take a look at who are the named plaintiffs in all the lawsuits fighting for your Second Amendment rights, whether it's in Illinois, Michigan, New York, California, Oregon, Washington, whether it's on the federal level, whatever it may be, these four organizations are the ones that are always the named plaintiffs. And unfortunately, there's simply just not a lot of other organizations that are truly in the trenches getting their knuckles bloodied for you. So if we are thinking about giving to organizations that are truly fighting for your Second Amendment rights, that's who I consider, but I digress. Okay, now let's talk about the case of Mock v. Garland, okay? Because the Firearms Policy Coalition is challenging the pistol brace rule on two separate grounds. Now, the first ground is the one that we would expect, right? They're challenging it under Second Amendment grounds, and they most certainly are. However, the one I want to focus on a little bit more today, because I think some of you probably are not going to be particularly familiar with it, and it's something that we really probably should spend time at least geeking out on a little bit, that it also violates the APA, the Administrative Procedures Act, okay? The Administrative Procedures Act is a huge piece of federal legislation that governs all executive agencies, all agencies that sit under an Article 2 branch of government on the federal level, which of course includes your Bureau of Alcohol, Tobacco, and Firearms. Now, the APA doesn't really give executive agencies power. What the APA does is it essentially limits the power of these executive agencies. And but for this amazing piece of legislation, executive agencies which are already running amok would be running roughshod over all of us, okay? Now, one of the things that the Firearms Policy Coalition is arguing here is a pretty obvious one. It's an argument that every single one of you makes in the comment section every time we do a video on this, and you guys are all right, which is, hey, you know what? The APA limits what executive agencies can do, and since they are executive agencies, one of the things they can't do is create legislation. Oh, that's right. Yeah, they can't create new laws, you see, because we have a whole separate branch of government, Article 1 branch of government, that actually does that. And the way the Firearms Policy Coalition put it in their pleadings was, the Attorney General has the authority to enforce the Gun Control Act and the National Firearm Act, but lacks authority to fill gaps or legislate. And the other thing in pointing out that this was really an end around to legislation, which is exactly a direct violation of the Administrative Procedure Act, was the obvious political undertones to everything that occurred here. As FPC correctly pointed out, once elected, President Biden urged Congress to swiftly pass gun control laws. When Congress did not act to the Biden administration's liking, President Biden instead called upon the agencies to dramatically expand their interpretation of the congressionally defined term rifle to accomplish the legislative agenda Congress itself declined to adopt. The final rule, inspired by the Biden administration's promise, seeks to end-run Congress and place restrictions on the ability of peaceable Americans to add minor modifications to their pistols. And then, of course, Firearms Policy Coalition went on to further plead, despite this fundamental tenet of separation of powers, President Biden has both expressed and advanced his plan to expand federal firearm regulations regardless of whether Congress concurs, in the direct contravention of the constitutional limits on his executive authority. And that is exactly what is occurring. So that is one of the attacks under the APA. But there's more, because they're also saying, hey, listen, Administrative Procedure Acts strictly prohibit passing vague regulations which simply are impossible to enforce because of the vagueness. And what it really typically means is it provides the executive agency way too much discretion to how to enforce it. Sound familiar? Okay. And one of the very interesting arguments here, is that, hey, listen, you guys published this first draft of the rule and you gave us this big $49.99, and at least that had theoretically objective criteria in there. And then all of the hundreds and hundreds of thousands of comments were all in relation to this form $49.99 because that's what we thought we were going to be dealing with. However, then when you publish the final rule, you abandon the $49.99. While some of us were thrilled with that, they adopted all new criteria for which the public never had an opportunity to comment. And actually, if you take a look at the old $49.99, and then you take a look at the new Code of Federal Regulations as published in the new rule, we have removed several theoretically objective criteria and attached a couple of rather subjective criteria. And the Firearms Policy Coalition takes exception to that, and rightfully so, in stating, the final rule unlawfully abandons the centerpiece of the proposed rule, a worksheet setting forth objective criteria for identifying rifles, short-barreled rifles, and firearms for a purpose of various federal laws. Instead, the final rule adopts a 6-factor balancing test that relies on far more subjective considerations in defining these terms. Nothing in the agency's notice of proposed rulemaking telegraphed that such a change was being contemplated, and thus the public was not given adequate opportunity to comment on the criteria that the agencies ultimately adopted. And then, of course, another component that is being argued under the APA, and again, this is really well-crafted pleadings, is hey, listen, what the ATF is doing here is exercising their discretion to redefine or further define terms that don't need any further definition because Congress already defined a rifle. Congress already defined pistol. Congress already defined short barrel rifle. The definitions are pretty clear. They're relatively objective. There's objective criteria right there. Now, the ATF wants to take a pretty clear law and say it needs further definition that far exceeds the scope of what they should be doing here. And this whole bit about the fact that a pistol brace could provide a surface area that could be used as a stabilizing support against the shoulder is irrelevant when you consider it the way the Firearms Policy Coalition pled it, when the agencies claim that by providing surface area, which can be used to facilitate shoulder firing, the stabilizing brace transforms the pistol or handgun into a rifle. And yet, Congress is presumed to include and exclude language knowingly and intentionally, and merely making it more possible to fire from the shoulder does not negate the fact that the weapon is still both designed to be fired with one hand and conveniently capable of being fired with one hand, nor does it change the fact that it is a pistol or revolver and thus exempt from regulation under the NFA. And then, in advancing their arguments as void for vagueness, Firearms Policy also pointed out, additionally, the final rule is void for vagueness because it assesses in an undefined multi-factor balancing test both objective design features and other factors, the latter of which are frequently subjective. And, for example, if you want to talk about subjectivity or the expansion of other criteria and the dangers thereof, FPC also points out the inclusion of marketing and promotional material not only raises concerns with vagueness and fair warning to any given owner of a pistol brace, It also raises First Amendment concerns from imposing liability on the manufacturer and customers based on speech. And what potentially makes this argument incredibly effective is that the void for vagueness argument, when we're talking under the Administrative Procedures Act, can be somewhat a gray area, unless, of course, that administrative procedure, that particular rule-making order, affects a fundamental constitutional right, because firearms policy correctly points out the void for vagueness test is particularly stringent where the vagueness can chill the exercise of core constitutionally protected rights, such as those protected by the First and Second Amendments. Then, in addition to all of those really good arguments, there is obviously a challenge under the Second Amendment grounds. And this is an argument that many of you have pointed out. And essentially is this, is that we know that there is federal regulation that is permitted under the common use test of firearms which are deemed to be both dangerous and unusual, okay? However, the ATF is saying, hey, there could be as many as 3 million of these, and we know there are a lot more than 3 million. There's probably at least one state that has 3 million of these, okay? And if there really is as many as 40 million, which has been some of the high-end estimates, then how unusual are they? Okay, I think all firearms in the hands of the wrong people or untrained people are dangerous, but is it dangerous and unusual? Because the test, despite the fact what some on the gun-grabbing left will say, is not dangerous or unusual, it is dangerous and unusual. And as FPC put it, lastly, the agencies themselves acknowledge brace pistols are exceedingly common today, numbering at least 3 million by the agency's own estimate, although the actual number is likely higher, which a full review of the record in case may reveal. By prohibiting plaintiffs from possessing, selling, and purchasing popular semi-automatic braced pistols absent NFA registration, the final rule directly infringes plaintiffs' ability to keep and bear arms within the meaning of the Second Amendment's text. Okay, the case once again is Mock v. Garland in the Northern District of Texas. We're going to put the links for it right down below in the description box. Now, this is the first of what I anticipate will be several lawsuits, and as more begin to drop, we will get you up to speed. As more begin to progress through litigation and come towards fruition, we will keep you posted. If you have any other questions about the pistol brace rule, check out all of these videos that we have done here. Hopefully they will cover some of the subcomponents and questions that you may have. In the meantime, if you have any other questions, you guys know the drill by now. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being a lawful and responsible gun owner, like we preach all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.